Analysis now, legal analyst Mpumelelo Zikalala has been following these developments. He joins us live from Durban this afternoon. Mpumelelo, as always, a pleasure talking to you. What do you make of what Bester is describing as these inhumane conditions he's being held in, 23 hours a day of solitary confinement? Let's not forget that he is a high-risk prisoner who has escaped before.
Good afternoon to you and also to your viewers. I think it's a very important point that needs to be considered. Now you go back and say, what is the procedures that have been accepted by the correctional services? What do they do on a normal basis, despite the fact that the person that they are looking after is not Mr. Thabo Bester? If what they are doing is within their provisions, if what they are doing is within the law, then they have no way of being able to challenge it. So if there's any discrepancies of something that the department has done, then you take it to court and you say to them, these are my rights and your obligations as pertaining to a person who's been incarcerated. Provide those to me because I'm not going to have a fair trial. Now, to go and ventilate those within a court which is supposed to deal with the state of readiness of another trial is not going to assist you in the long run, which is what the judge was at pains to try and explain to the legal rep to say, we may be in a forum in which you must stage all those disputes. However, I'm not going to be the one that's going to deal with them. Go back and check whether within those provisions, is the department even entitled to provide those things? If the answer is yes, then you can continue. If the answer is no, then think about the alternative that can be able to utilize.
So let's stick with the issue of solitary confinement, Mpumelelo. Where does this fall in the ambit of someone who's in a CMAX prison?
It falls within the ambit of correctional services. They would say, we are the ones that are able to grade a particular prisoner that is here to say that you are high risk, you are going to stay in solitary confinement for so many hours. Whether that is inhumane or not, it depends upon the regulations in which the department is supposed to stick with it. Ordinarily, I do not think it would be there would be any reasonableness to say someone must stay in solitary confinement for so many hours, unless there is something that says, according to the procedures and the practices that we have agreed or we have deemed this person to be of high risk, and they are going to stay in solitary confinement because this is what they've engaged in. The mere fact that they might have escaped previously, or they are currently running within a particular trial, he hasn't been deemed as someone who's guilty. But it may be that from the side of correctional services, they are saying, we are not going to take any chances. We are going to provide the bare minimum in terms of the humane expectations which is expected from us and nothing more. And if that includes that particular individual staying in solitary confinement, that is what we are going to do.
What about the issue that he's brought up about not having access, for example, to the kinds of resources that he says he needs to prepare for his trial? His lawyer says the Constitution, Section 35 of the Constitution, guarantees every person the right to be presumed innocent, to remain silent, to challenge evidence, and to be provided with adequate facilities to prepare for a defense.
Now, the type of facilities in which he is looking for are some which are, I would say, they're extravagant. What the Constitution is really saying to that is to say, we are going to give you access to your legal rep. Your legal rep is going to sit down with you and be able to do all those things. Now, it's the lawyer which does the research and the drafting and not Mr. Bester. So he does not need any aids which are going to assist him in whatever manner. If those particular aids are prohibited to be inside prison, then those aids are not going to be there. A laptop, a tablet, or anything of that sort is only there for educational reasons and nothing else, and not for the individual to be able to prepare for trial. So if you are saying you need those things so that you can prepare for trial, then the next question is, what exactly are you preparing? You don't draft any documents. The only thing which is required from you is the relocation and the stating of the statements of the sequence of events to the best of your knowledge, which is then transmitted to a legal rep and nothing else. So you don't need those aids in order for those aids to assist you. And nonetheless, if you look at the regulations and the rules which apply within prison, those things are prohibited. They're not supposed to be there. So why should we make a special dispensation simply for you so that you can be able to say, I'm preparing for trial? Even when it comes to consultations, there are two ways of doing it. Either you say, I'm going to book you in and make sure that I'm able to consult with you and we are going to talk because I want us to ventilate certain issues. Or on the day, for example, like today, instead of going back early to prison, then we have more or less the whole day to sit down and be able to consult, which is usually the practice which is being done in courts all over South Africa. There's a day specifically booked for consultations in which a prisoner will be booked out, go to court and be able to consult within the grills and then be able to prepare for trial in those instances. Unfortunately, they can't ask for something which is more, because it's the rules and regulations that we live by, and it's weighing off the risk of saying that I'm affording you a right in order to prepare for trial, and also the risk of you escaping and the risk of endangering any other inmates or prisoners that may be near you.
I mean, one wonders what would be the case if all prisoners demanded laptops, tablets, on the pretense of wanting to prepare for their trial.
It's something which is, for a lack of a better word, and with all due respect, a bit absurd. It can't be done. Then the question would be, what are you requesting the laptop or the tablet for? Are you going to draft any pleadings? The answer is no. Do you want to prepare any statements which are going to be submitted? The answer is no. The only thing that you need to do with your legal rep is to sit down and deal with the statements that have been provided to you by the state, and think about your defense as to what your defense is going to be. So there's no production of certain information or certain documents that have been drafted which will be required, which then begs the question, why do you need the laptop and why do you need the tablet, especially when those particular items have been prohibited from being within our correctional facilities?
Certainly. Well, unless you want to have a birthday party virtually from your prison cell, I suppose a laptop would come in quite handy. Mpumelelo, I want to ask you a question about the proceedings this morning, insofar as Thabo Bester's prison escape case is concerned. Now anticipated to begin in February of next year. It's quite a high-profile case. Are you concerned about how long the process of getting to trial is taking?
Yes, I would. And I think all the other co-accused would be too, because each time your liquor rep goes there, they charge you money. Then the question, who pays for all those fees? For example, like today, where you only go to court for like maximum 30 minutes, and then you have to go back home. And then come back February, probably we are going to do the same thing. Because from what I heard, it's as if it's going to be enough for another pre-trial, one-day event, and then you go back again. The only time in which would start to see some action in a witness going into the witness box is when the trial has been set for a day, which is for days, which is more than one. So the expenses that come with it, the stress and the emotional stress that comes with it is a bit of a concern. But most importantly, let's think about the victims. You have a mother that says, my child was killed within this whole saga. I don't know how that has taken place. I want to know the nitty-gritty details so that justice can be served. And those individuals that killed him can then be punished accordingly. Now, if you are going to delay for all these months, it then begs the question as to, are the wheels of justice grinding really slowly? But most importantly, I think what the judge ought to have said, just for procedural basis, to say, use this time to consult, use this time to go and speak with your clients, use this time so that when you come back in Feb, no one is going to say that you haven't received any opportunity to consult with my clients. I do not have full instructions because there was no time. This is the opportunity to be able to prepare for your case.
That's interesting that you say that, because Thabo Bester's lawyer says, just because of the issues that they're experiencing insofar as his incarceration is concerned, there has been this lack of being able to consult and being able to prepare properly with his client, just given the kinds of conditions Thabo Bester is being held in. What do you make of that? The lawyer says that there isn't an opportunity, and that's why these delays are now happening.
But then you must, whatever that you must allege, you must be able to prove in court. So you must come with papers which are going to say, I've sent these following requests, 5 letters, to say that I want to go and speak with my client. All of them have been denied with no appropriate reason. So I'm seeking an alternative to say, if I can't consult with them in prison, can I consult them here in court? Because there are grills which are there. You can go down to your client before you appear in court. Let's sit with them for a 4 or 5 hour session, be able to deal with all the statements that are there. So it's all the avenues that you must be able to show as a person who's complaining, to say, I've traversed all these things, trying to protect my rights in terms of Section 35. All of them have been dealt a blow for no apparent reason. I'm now taking the correctional services to court to force their hand to give me an opportunity to consult. But what you can't do is to waste all this time and not provide any information on only activities that you have engaged in, to say to the court, I'm making a bona fide application. This application needs to be attended to by the court because I've tried all means to be able to get the attention of the appropriate authorities so that you can be able to consult. Unless if what you want is to consult in a much more extravagant way, in a way in which is not usual, by saying that I want 2 or 3 days with my client within my leisure, so that we can be able to stimulate the mind and be able to remember things. Now, that can't be granted by the court.
So 7 months now until the prison escape case resumes in court, February of next year. I mean, cases drag on in court all the time, right, for various reasons. Senzo case has been in court for coming up 10 years. What kind of impact does it have, though, to have cases that are high profile, not only on the victims and the victims' families who may want to move on with their lives and find some type of closure, but for the case itself from Mpumelelo to drag on months and sometimes years at a time?
On two most important things, the quality and the quantity of the evidence, and that applies to both sides. That's the state and the defense. Remember, from the state, you have the burden of proving beyond reasonable doubt that the persons that are accused are indeed guilty. In order to be able to prove that, you need evidence which is both documentary and evidence which is going to be stated by a human being. Now, we don't know the lifespan of a human being. The last thing you want in a case as major as this one is for someone to pass away, for someone not to be interested to be a witness anymore, so for someone to relocate to another country. Now, when you need them as witnesses, you now have to fly them back into the country, be able to host and pay for the accommodation, and where the cost or where the money is for those when the department is already struggling to meet its all financial obligations. So the quality and the quantity of the evidence is then impacted on both parties, which then have the effect of making of the trials being too long, or when we are about to get into the nub of the merits, we are not able to do that because we do not have enough evidence either to rebut or to say this particular individual is guilty. And that paints the whole justice system in a bad light, because it then seems, what good is it if you're going to go and report a particular matter if it's going to take a very long time for you to find the justice in which you are looking for? From the side of a person who was an accused, what good is it for me to stay within the prison system or to be branded as an accused when at the end of the day I'm going to be exonerated for a lack of evidence?
Mpumelelo, in your experience, and as we close off our conversation this afternoon, is there ever a situation where the court will say, no, I don't buy your excuse as the legal team of person X, that you are unable to have any availability for this case this year, and I compel you to continue at the next court date?
There may be instances in which the court will issue out that direction, but they do that very sparingly, because what they don't want to do is to change the procedural aspect of the matter. That's even on the merits, there was a case and the person was indeed guilty, but purely on a procedural flooring, the person must be deemed to be not guilty. So what they will try and do is to provide those innovative solutions to say, if you haven't done it in a conventional manner, let's see what other alternative is there. The other one is the one of saying, because you're saying you can't consult, you will consult on the day the matter is going to be set down. So I'm recalling or setting down this matter again within the next 2 months, each day on the third week of the month, so that you can be able to come to court, sit with your client, consult and deal with all the things that you say you cannot deal with when you're in prison, or issue out an order to say, prison officials, make sure that this particular inmate has been provided with the following, and you must come back and report to me if there's been instances of non-compliance, because at the end of the day, whatever that the court issues is a court order that needs to be complied with, and non-compliance with those, it means that you are committing a criminal offense.
Mpumelelo Zikalala, legal analyst, thanks very much for joining us.